Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. And up today, it's summer, it's hot, here in Missouri, Kansas area. It's already been pretty hot. And right now, when I'm recording this, the week ahead is forecasted to be pretty rough. And so, what do we see here at our personal injury law firm during the summer? Heat related injuries. And it happens more than you probably think and more than we would like to see. But unfortunately, whether you're in construction or landscaping or factory work, the heat is a real threat. And, you know, the biggest thing obviously that can come from heat exposure is heat stroke. And again, there are other examples of where this happens. Sadly, not only do we see people affected by the heat on the job, but it can even be, at an outdoor sponsored event, maybe a daycare, something like that. But we're going to break down who's legally responsible and what you can do if you or a loved one suffers a heat related. So again, biggest things that come out of heat exposure is the heat stroke. Obviously is a very serious condition. Heat exhaustion can happen, dehydration, and sun poisoning. I don't know if you've ever heard of that, but if you get too much sun exposure, you can experience sun poisoning. And again, all of these can be fatal or they can cause long-term complications. And again, we've had these. We have had mainly in the work setting, but we've had factory workers that have gotten overheated and have had long-term effects because of it. According to everything you will read out there, every summer cases of heat stroke rise. And again, many are preventable. These are preventable injuries. And so what does it look like for workers? Workers that are regularly exposed to heat. As one example, Missouri State University reminded employees that outdoor heat illnesses from cramps to stroke can be covered under workers' compensation if it's tied to their work activities. Employers are advised to provide hydration, shade, training with a focus on reporting incidents promptly. There's been some Missouri case law dealing with heat exposure. And there was a case, for example, where in the courts, there have been cases dealing with heat exposure. And Missouri courts continue to rule that supervisors and coworkers can't be held personally liable for heat stroke fatalities unless there was clear intent to cause harm. This keeps most heat stroke claims within the exclusive remedy of workers' compensation. But this is important because what you need to know is that a work-related heat exposure injury is covered under workers' compensation. And again, we've had those. So in the Missouri work comp world, work comp covers injuries arising out of and in the course of employment. And again, heat stroke, the biggest one, definitely qualifies if you're especially working outdoors, say, for example, roofers, road crews, agricultural workers. They all generally qualify if they get overheated and experience an injury or a condition. OSHA, which is the Occupational Safety and Health Administration, they provide guidelines to employers insisting that employers must provide water, rest, and shade to employees. Heat illness prevention plans are encouraged for employers, and a lack of training or ignoring warning signs may constitute negligence for OSHA purposes. Now, again, in the work comp world, if you suffer some type of heat related injury or condition, your medical treatment should be covered. If you have to be off work, you should get weekly benefits. And you very well, if you have long-term residual effects from this, you would be entitled to a disability settlement, just like any other injury there is in the work comp system. Now, keep this in mind. If for some reason your employer ignored the signs of heat exhaustion, heat stroke, or pushed you to keep working in extreme heat, there might be an entitlement to something above and beyond the basic coverage. According to data from the Workers' Compensation Research Institute, heat-related claims rise exponentially with temperature. So the hotter it gets, the greater number of people experience heat-related injuries or conditions. I mean, it makes sense, right? So when the temperature hits 90 to 95 degrees, 7 times more people experience issues with heat while they're on the job. When it's 95 to 100 degrees, 11 times more people experience that. And when it goes above 100 degrees, 18 times more people have some problem with a heat exposure type injury or condition. 90% of the cases, according to this data, occurred on days over 80 degrees, and 56% occurred when the temperature went over 90 degrees. So, who's most at risk in the work setting? Well, again, according to this report, workers under 35, 50 to 300 heat related injuries were reported per 100,000 comp claims. Workers with only 1 or 2 months tenure on the job, there were 345 per 100,000 claims. So these two areas of workers represented the most frequent type of heat related injury or condition. Now, what about in the personal injury world? So outside of work comp, again, there have been examples of kids in daycares, being outside for too long or parked in school vans with not the appropriate air conditioning, things like that. The elderly, obviously, the elderly are always at greater risk when the heat goes up. And there have been cases where there were poorly ventilated nursing homes, things like that. There's also been situations where attendees at public outdoor events without proper cooling and proper shelter have experienced heat related illnesses, injuries, or conditions. In those cases, there was a duty of care breached by those in charge. Again, whether it was the child care providers, the nursing home, or maybe event organizers, not ensuring that the people that have paid to come to this event were given proper water, shade, or other relief from high heat conditions. So what does it look like as far as damages that come from a claim like that? Well, obviously, if you incur medical bills, if you miss time from work, obviously going through the experience, the pain and suffering, as we generally call it, all of those things can be compensable in a claim against someone who is potentially negligent in the situation. Now, again, in extreme situations, extreme neglect situations, punitive damages may come into play. And just as a refresher, punitive damages are damages that are meant to punish the wrongdoer. Their negligence rose to a level of a recklessness, a willfulness, and therefore the law provides a different set of remedies for that type of behavior. So what do you need to do if you or someone finds themselves in a situation where they've experienced a heat related injury or condition? Well, obviously, number one, you've got to seek medical attention. And you've got to make sure in the work setting that your employer knows what happened. This is one of those things where if you go home and you start feeling bad and you end up getting medical care, say that evening or something like that, your employer, you need to put them on notice as soon as you possibly can. Because if you're going to make this claim in the work comp system, the notice requirement is very important. And I've discussed that on previous episodes. Again, documentation of the conditions and whether that's, the temperature, any coworkers, things like that. For any reason, if there's photographs showing you in that situation, your condition at the time, all of those things could become very important in making that claim. And again, you need to make sure you understand the official reporting requirements for the work comp system. And again, in a previous episode, which I'll put up here for you to link to, we talk about the reporting requirements that are necessary for Missouri and Kansas workers' compensation claims. Again, if you think you or someone has been injured or suffered a heat-related illness, and you think it's either work-related or you think it's due to someone else's negligence, I would always encourage you to reach out. You can reach out to us. It's always a free call. And we can see whether or not what you experienced and what you have going on rises to the level of a claim that can be made against someone else. We're always happy to take a look at a situation like that. Again, we've handled them before. We know what to look for. But the other part of that is we always say it's better to act sooner rather than later, because evidence can fade. You can go back, you can get weather related data from historical sources, but the sooner you are, or the closer you are to the event, it always makes things easier, especially when it comes to witnesses and things like that. So you got to remember as well, Missouri and Kansas, you have 2 years to make that work comp claim. And for personal injury in Missouri, you have 5 years to make that claim. Kansas is 2 years. So again, there's important deadlines in place. And again, there's important reporting requirements in place. So you really don't want to mess around if you find yourself with some kind of a serious heat-related condition, illness, or injury. And remember this, heat stroke isn't just a medical emergency. It can be a legal one as well. So whether you're an employee, a parent, an event guest, whatever it looks like, you have rights and you need to keep that in mind. So we're always here. We always encourage reaching out, and be safe this summer as those temperatures continue to rise, and do everything you can to prevent a serious condition coming on that could potentially cause you lifelong effects. Until next time, be safe and be well.